In this last section of this presentation, we will discuss the implementation process of Forest Rights Act. And I will try to present an idea of legalism from below to give you some important points related to the enactment and implementation process of the FRA. Now, when we focus on the implementation of FRA, we'll find that the implementation process has not been satisfactory, though private property rights, which is related to the regularization of land rights of those families who have been living on a particular land and doing cultivation on that land. So that private property right over the so-called encroached forest land have been primarily implemented. One can find many irregularities in the regard of private property rights too. In many places, OTFD could not get rights for forest land. Why? Because OTFDs must prove that they have been living on a particular forest land or doing cultivation on a particular forest land from last 75 years and 3 generations. And uh, in most of the cases, OTFDs, that is non-tribal forest dwelling communities, which have been termed as other traditional forest dwelling communities in the FRA, have faced lots of problem in presenting proof that they have been living on a particular piece of land from last 75 years. So in most of the cases, they have not received any kind of patta. Secondly, the FRA's community rights have largely unimplemented or partially implemented because they challenge the forest department's dominance. So they created, that is, it means forest department officials, they created obstacles in their implementation. And third, though FRA talks about making critical wildlife habitat in national parks and other protected areas to create human-less space for animals, the Forest Department violated this provision. In many cases, it tried to displace tribals without settling their rights or taking their consent or without any scientific study. This is a data, it's a slightly old data from 2016, but it gives us an idea that how different kind of claims were received and title were distributed. So basically, we can find that the performance of different states have been different, uh, and in most of the states, the status of community rights is not that much satisfactory. And if we focus on data, we can find that 47% of claims rejected, no grievance redressal mechanism, and as I mentioned, OTFDs are facing lots of problems and no implementation in protected areas. This is another chart which gives you an understanding that how far the claims have been rejected. So we can find that in Andhra Pradesh, 49.42% claims have been rejected. In Chhattisgarh, around 59% claims have been rejected. In Himachal Pradesh, 86.20% claims have been rejected. Okay, so in most of the states, we can find that more than 40%, apart from some exceptions like Odisha or Rajasthan, we can find that most of the claims have been rejected. Now it is a fact that there are many limitations of the FRA and it is not implemented correctly. So before moving towards the examples where local communities have used it to assert their rights over forest land and its resources, I just want to underline one point that uh, why Forest Rights Act has not been implemented properly. The reason is that the Forest Department officials have treated this law and the claims based on this law as a kind of encroachment uh, on their rights. So they always tried to create some kind of obstacles. So, for example, in many protected areas like Rajaji National Park or Dudhwa National Park, they have asserted that for them the important or most important law is Wildlife Protection Act. They are working on the basis of Wildlife Protection Act, and they are not ready to give or accept any kind of rights based on any other law to local communities, tribal communities. So we can say, we can find that actually the sense of ownership over forest and its resources by the forest department has played an important role in non-implementation or partial implementation of the Forest Rights Act in most of the areas. And as we discussed, some of the provisions are really difficult. OTFDs are facing lots of problems. But I also want to underline this point that in many areas, though laws like PESA and FRA have been partially implemented or non-implemented, but local communities have used them to assert their rights on forest land and its resources. And in this context, I want to mention a Supreme Court judgment in 2003 in Niyamgiri case. The court directed state government, that is Odisha state government, based on PESA and FRS provisions, to consult with Gram Sabha of concerned villages before permitting mining on Niyamgiri Hill. In their meetings, all Gram Sabhas rejected the proposal of mining. There are many such examples. So what we have to remember about Niyamgiri Hill is that after that judgment, the state government forced to organize some Gram Sabha meetings. It selected only few Gram Sabhas. Okay, but and also the private sector companies, Vedanta company, Goons, also tried to terrify, the tribal people. But most, not most, but all the Gram Sabhas rejected the idea of mining. But later on, some new kind of developments happened. But right now, I'm not going in the detail of those developments. My point here is that local communities, the most dispossessed communities, have used these laws or the provisions of these laws to claim that actually FRA and PESA gives them their right over habitat, and any kind of mining or any kind of conversion of forest land should not be without their consent. And then they rejected this whole proposal. So my point here is that there are many such examples, but undoubtedly the forest dwelling communities have not received their rights as promised in the FRA. They are still struggling for the proper implementation of the FRA in different parts of the country. Now, in my field work, I found that in many forest areas, forest dwelling communities are struggling for their rights and using the FRA to assert their rights over forest land and its resources. I want to give you one example of from Dudhwa National Park. In Dudhwa National Park, the Tharuk tribal communities are in a predominant situation. And in this national park is situated in Lakhimpur Kheri district of Uttar Pradesh. And all villages except two villages are settled in the periphery of the Dudhwa National Park. And they want community rights in Dudhwa National Park because they uh, they are dependent on the resources from the forest. But from last many decades, they have been facing the arbitrary behavior of forest department officials. They are extracting some kind of money, some kind of taxes, to illegal taxes to the Tharu tribal men and women. But with the enactment of FRA, and they mobilized themselves. In fact, their organization played a role as part of the umbrella organization of Campaign for Survival and Dignity in mobilizing tribal people for the enactment of this act. So when this act was enacted, and when the implementation process started, the men and women of Tharu communities claimed their community forest rights over forest land or over the resources of forest. Obviously, forest department opposed it, but they the implementation of this act gave Tharu men and women some kind of confidence. So earlier they were going to forest to collect some kind of forest produces, but they had a feeling of doing something illegal. Now, with the enactment of Forest Rights Act, though the act has not been implemented in Dudhwa National Park yet, and there is no legal document which is giving them community rights over forest resources, the Tharu community people are feeling that there is a law passed by the parliament which gives them rights over forest resources. So they are going to forest areas, they are collecting all kind of minor forest produces, and they are going in large groups and they are opposing the arbitrary behavior of forest department officials by claiming, by saying that look, there is a law in their favor too. And similar experiences are there in Rajaji National Park, though the mobilization of in Rajaji National Park is weaker, and there people are facing lots of problems in tackling the suppressive measures by the forest department. But the larger point I'm trying to present here is that we can find an emergence of legalism from below in the forest areas. By legalism from below, I simply mean the tendency of marginal groups to use law to assert their rights over forest land and its resources. And I also want to argue that this legalism from below emerged in tribal areas or in forest areas of our country uh, from last 3-4 decades. Obviously, it emerged with the emergence of grassroots organizations who played an important role to give people an understanding about the importance of law. Tribal people themselves realized that actually they have been suppressed by the forest department on the basis of certain provisions of certain laws. So they fought for a law which actually gives them, after its enactment, which gives them certain important rights. And now they are using this law to assert their rights. So the claim, when I'm saying that there is a legalism from below in forest areas, the claim is not that all tribal people or all forest dwelling people are now expert of laws. No, but the claim is that they understand certain provisions, certain key provisions of these laws, particularly FRA in this case, and maybe PESA in Schedule 5 areas. So they understand important provisions and they use these provisions to assert their rights. They use these provisions to counter forest department officials or their suppressive measures. So the point is that though FRA has not been implemented properly, we can find that there is a legalism from below in forest areas. Forest dwelling communities are using law to assert their rights over forest land and its resources. And in this sense, we can find that law has played an important role to democratize the governance of forest in India. Though we cannot say that the forest governance has totally changed, but we can find that now people are using law to challenge the dominance of institution, state institution, that is forest department, and they are using law to assert their democratic rights. Now there is one question, and the question is related to this point, that why the idea, the FRA has not been implemented properly, or why PESA has not been implemented properly. And I mentioned this point earlier too, and I just want to reiterate it or I want to present it more explicitly now, that the basic reason behind partial implementation of the FRA is the existence of legal pluralism. And what is the meaning of legal pluralism? The meaning of legal pluralism is simultaneous existence of different laws which overlap and contradict each other. So this situation gives opportunity to all parties to use different laws according to their own interests. So when tribal people or Adivasis or other forest dwelling communities claim their rights on the basis of FRA, forest department officials claim that no, for us, FRA is not important. For us, the important law is Indian Forest Act of 1927, which is valid according to Indian Constitution, or Wildlife Protection Act of 1972. So in this, due to this situation, we can find that uh, that both parties or different parties actually use different laws to enhance their arguments, which creates a situation where proper implementation of one law, uh, or particularly the law which the weaker party is using, become very less probable. So this is the situation in the case of FRA2. Now, in the continuation of different kind of laws, we can find another law which actually affects forest governance in our country, which was passed in 2016 by the Parliament. The title of this law is Compensatory Afforestation Fund Act 2016, which is related to the use of the fund accumulated due to the diversion of forest areas according to the Forest Conservation Act 1980. The CAFA gives all power to the forest bureaucracy to decide the use of the fund. So it is a kind of centralization of power. Another thing which happened about the implementation of Forest Act is the an order by, not exactly judgment, but an order by Supreme Court on 13th February 2019. The Apex Court directed state governments to evict forest dwelling scheduled tribes and other traditional forest dwellers whose claims over forest land were rejected under the 2006 law. Because, as I mentioned, many claims were rejected. And once claims are rejected, uh, people who claim that they have been living on a particular land from for example, if they are OTFDs from 75 years, or if they are STs uh, before 13th December 2005, the cutoff date, and once this claim was rejected, it means that they have been illegally living there. So obviously, state can evict them from that place. So this was the order of Supreme Court. However, it led to a wave of protests, following which the central government intervened, and the Supreme Court ordered a stay, asking states to submit detailed affidavits about procedures followed to assess the claims. 300 million forest dwellers across India had a sigh of relief after the Supreme Court stayed its own order to evict encroachers on February 28 this year. So, what we have to remember, and I just want to see this point as conclusion, that FRA has changed the nature of forest governance in India, and its implementation has been partial, and many communities, particularly the OTFDs, have not received their titles, or this law has not been implemented properly in protected areas. Still, it is crucial law because it was not only the result of legalism from below, but it also enhanced it, or it is enhancing it continuously. Now, forest dwelling communities are using this law to assert their rights over forest land and its resources. So, I just want to conclude my discussion by saying that Forest Rights Act, its enactment and its implementation process, both of them has many limitations, but though there are these limitations, we must uh, understand this point, that it has changed the landscape of forest governance in India, because this law gives many crucial rights to forest dwelling communities, and these forest dwelling communities have actually uh, understand now that they have an important tool in their hand to challenge the dominance or suppressive behavior of forest department. And in this sense, this law and its implementation has led to democratization of forest governance in our country. So I'll stop here with um, this particular point, and I hope that this presentation would have given you some kind of understanding about the situation of forest governance in our country and its changing nature. Thank you. Namaskar.